I'm doing great. Good morning, Your Honor.
Good morning. So, can you tell me any thing causing you concerns with your recovery right now?
Honestly, everything's going really well. I can't think of anything off the top of my head that could get in the way of keeping me from being able to work on myself.
All right, and I see you've started your classes at NMC there, and how's that going so far?
Well, it doesn't start until August, but
Oh,
yeah, I do have all my classes already. I'm signed up for my classes now. So,
okay. I just saw the hours there, Mondays and Wednesdays. So,
yeah.
uh, okay. Well, that's exciting, and let's see. So I know that you're back at your parents' home right now,
Yes,
and
sir.
how is that working out?
It's been great. I've been able to spend time with my mom and my stepdad and reconnect with them. And I've been able to help my mom out quite a bit because of her health issues. And it's been really enlightening for me, and just making me realize how many years, and it's not like I beat myself up for it, but just it just puts into perspective, how many years that I wasted, you know, romanticizing about how good of a person I was, why I was all messed up on drugs and alcohol, and how I thought I had it all figured out before. But now that I'm clean and sober, I can see how much effect I actually do have on the people around me and how much more I can do. Like now, if my family members need my help, I can actually help them. Before, I was so messed up all the time. Like if they ever needed me, it was impossible for me to be there for anybody. So being here now with my mom and my stepdad, it's really amazing because I can see how much everything has changed in myself and in my life, and just the amount of gratitude that I have, for AA and NA and everyone in drug court, and that's one thing, that I felt like I really needed to share, that I talked to Diana about, is that anyone who's new in the program, you have to realize that everyone on the drug court team, the judge, our PO, everyone is there to help you. You you have to realize that if you want to save your life and you want to be there for those that you love and care about, they're there to help you. So don't lie and tell the truth and do the work, So yeah, it's been an amazing experience. So really grateful.
Is it fair to say there was a time not so long ago your parents actually were they were kind of frightened of you? I mean, they didn't want you to be around because of that.
Yeah, I mean, I scared the crap out of my mom. I was so blacked out, messed up on drugs and stealing from her and asking for a gun. And I don't even remember. That's the sad thing. That's the sad thing. I wish I did so I could like be like, what the heck? And they were frightened of me. Like there's other people in my life that were frightened of me. My sister, she didn't want me around, around my niece because of how scary I was, all messed up on alcohol and drugs. And now my sister, she wants me to come over and hang out and spend time with my niece. And I saw her not too long ago, and she was just all like, "Geez, Josh," she's all like, "You are a completely different person." She's like, "Who are you?" Well, like I'm who I'm supposed to be. you know, this is who I'm supposed to have been this whole time. But like I said, I can't be angry, and beat myself up over it. You know, it was for some odd reason it happened the way it did, and I hit my rock bottom. And but yeah, everyone was afraid of me, you know. And I look back, and actually, I think I was the worst thing is I was afraid of myself, you know, and the things that I potential I had under the influence of things, you know. So.
Well, Ms. Lako shared a story with us about you going for a walk with your mom and your stepdad there, and how much your mother appreciated you helping and being there now. And so that's great to hear. And that's why, you know, when you say that we're here to help, those are the kind of stories that make it rewarding to do this job. And so I'm just glad to hear everything's going well. No issues. I know you are working on long-term housing, and but enjoy the time you got right now with your mom and your stepdad there. So, all right. Is there anything else you want to share this morning, Mr. Kozer?
Just you know, the amount of gratitude that I have for, you know, like doing drug court. It's like I was telling, I think I told both Beth and Diana how, you know, I'm getting towards the end of drug court, and it's kind of bittersweet. You know, it's like I'm kind of miss being a drug court. You know, like coming to the meetings and coming to the drug court, you know, and talking to Diana and talking to Beth and talking to you guys, and it's gonna be kind of gonna miss it, you know. But at the same time, it's a part of life, and you know, I'm getting ready to move forward, and I got a gratitude list of really long, miles long. So that's all I got. I appreciate it.
Okay. All right. Well, nice talking to you this morning. Let's go on to Raymond Swisher. And so, Mr. Swisher, how are you doing today?
I'm doing okay, Your Honor. Thank you.
Okay. Let's see. And you're working on possibly living at Unity House, and any new word on that?
As of right now, no, but I did have verbal contact with them late evening last night, and they were getting ready to have their house meeting, and I am supposed to hear from them sometime today.
Okay. All right. Well, keep us posted anyhow. Now, let's see. There were some PBT issues that we need to deal with, and that was you had a miss on 7/12, and you were 3 minutes early actually on 7/15 and 7/16, and you were 4 minutes early, and missed an appointment on 7/15 with your probation officer and a counseling appointment. And we talked about this in the team meeting yesterday. And of course, the early tests are because you're trying to work around your breaks at Sara Lee. And so what we've come to believe is that this third shift thing is just, it is not conducive to working this program. And I think you've already talked to Beth a little bit about that. And, you know, I definitely want to see you employed in Sara Lee as one of the better employers in town. And what I want to say is the last person who had this type of a problem they worked with, I think it was Sarah Lee, to move to a different shift. And I know you're concerned about asking for that, but you know, if you're not able to do this program because of your work hours, you know, I don't know what to do about that. And so, I don't know. What do you think about all that?
I have put it in works with HR to be moved to another shift, and they said they would be in touch with me. I haven't heard back from them yet, as I am in ramp up period right now, and our schedules don't crisscross each other. And I will get a hold of Elaine today, and I will have an answer for Beth tomorrow about a shift change, I hope.
Okay. Well, what we're going to do is give you a week to get your, to move to a first or second shift. Second shift is fine. We've worked with people on that shift before, but it's apparent that this isn't going to work well at all on third. So let's see. And, you know, I know work is extremely important, of course, to everyone. And, but for the folks in this program who have moderate to severe substance use issues, recovery has to come first. And in addition to just the testing and, you know, being able to make appointments and that, it's also hard on your health and other things that are important to doing well in this program, working those late hours. So again, I'm going to give you a week to move to first or second shifts, work with Beth on, you know, keeping her posted. Hopefully they've already made the decision that they're going to do that. But one thing you can tell them is that we're requiring that you do that as part of the drug court program, because we just can't operate the program without that change. So that's another incentive for them to help you out there and to keep a good employee. Okay.
Yes, Your Honor.
All right. Because of the misses and knowing that it wasn't because of any use or anything like that, I'm just going to require that you prepare an essay, how to make recovery in drug court a priority. And if you could get that done by the end of the week, and that's about it. So let's see. Anything else that's causing you any concerns right now?
Just the Unity House is a major concern for me, and that's the main concern right now. And of course, the divorce is an issue, but of course, that's a totally different issue all by itself.
Okay.
But I know that through the help of NA and AA that I don't got to use over it.
Okay, and you've already, let's see, you're starting your counseling with Catholic Human Services. Well, you've got an appointment today, correct?
Correct.
All right, so that should be another help with dealing with that issue, and it's significant, and I'm glad that you're reaching out, and I think that this program will be good for you as you deal with all of that stress anyway from a divorce. So, okay. All right. Anything else you want to share today, Mr. Swisher?
No, Your Honor, I'm good.
Okay. All right. Well, let's go on to, let's see, Ms. Worm, I'm going to have you meet with our MIDC attorney. And so I'm going to skip over your case for right now. I don't see Mr. Jarboe here yet, unless I'm not seeing him.
He's in with Magistrate Rogers. I will ask him to jump over.
Okay, yeah, if you could see if he's able to break away, that'd be great. Okay, let's go on to Steve Ryder. So, Mr. Ryder, first of all, you've had this kind of cloud hanging over you about the drug testing, and finally that's come back, and it shows that it was negative, and so. Yeah, so, one of the reasons we were concerned is because you had a friend that had tested positive for codeine, and, and he's in sobriety court, and so it just seemed like there was something going on, and anyhow, we were all glad, frankly, to see that there wasn't a positive test, and so that's good news.
That is good news. And I know Beth was, she talked to me about it pretty much every time we talked. And I think we even talked an extra time this last before drug court. And she voiced her concern about it. And it was a little frustrating, but on the same point, like, I get it. I lived with said person, and I get exactly how it, and sometimes it's hard to trust people when you don't see them on a daily basis, and all we got to go off is those pieces of paper. But I'm glad that it's taken care of. I know it took like a month, but water under the bridge now.
Okay. So let's see. It says you're working on step 5 now, and can you tell me a little bit about that?
So we're at the point right now where I'm sitting down with my sponsor and going over like my resentments, and we started off that he's reading some of his stuff while I read some of mine. We actually took a break last weekend because there was a big NA cookout thing, I think, somewhere that he went to. But he actually gave me this really cool article about sponsors and trust. That I'm in the process of reading. It's pretty long. That he says thinks will help me through this process a little bit, because that was my biggest concern going in there, is I got to read these giant lists that I made about all this super personal stuff but it's it's so far it's been an experience that has been a lot easier than I thought going into, and I had some really good advice from other NA people and Diana and stuff, but I think I'm going to come out on the end of this like a lot stronger, and I'll have a better understanding of how to healthily confide and put my trust into people as well as receive it.
Okay. Can you give me an example of maybe one resentment that or a way that the program how you think you can benefit by going through your resentments, and and how that's going to help with your recovery?
Yeah, so like, let's see, like, one of the big like topics on my resentments, because we did them kind of in order from growing up, was when it got to be about 8th and 9th grade, in that area, I was bullied a lot, and and even confiding in my parents in the school, nothing was ever really done about it. And I think, there was a lot of drug use then. I was afraid to go to school, so I'd skip school and smoke pot with my friends, and going through some of that, I not only can I see kind of where my problem started to kick in, but also it kind of gave me some insight onto like, why I left my house and moved out early, and why I think I distanced myself from my parents so early in my life. So, I mean, there's a lot of there's a lot of self-discovery that's going on with this stuff.
Okay. Well, I'm glad to hear your, sounds like you're getting a lot out of it anyway. You're really applying yourself and learning a lot about yourself also. And sometimes we just need to take the time to examine our lives a little closer and figure out how we got to where we are. So
Yeah.
good. Let's see. Any word from NMC yet about the job?
Nope, still keeping my ear open. I'm gonna try and get a hold of them today after lunchtime, noon, and see if I can actually contact someone. I'm not sure who to get a hold of because it is a union, but my mom and brother both work there, so I think I'm gonna ask them if they can either have someone call me or if there's a number I can call. But I know it's slow going. I guess there was like 11 applicants, and I think they're only interviewing one person a day. So it's either supposed to be here now or I got to put a little word in their ear.
All right. Well, you're dealing with a bureaucracy over there at NMC, so
Right.
that makes sense. But I'll keep my fingers crossed for you. It sounds like a good opportunity, and maybe something long term anyhow. All right. So good luck with that. Is there anything else you want to share today?
Just that Raymond has been very proactive in trying to get a seat at Unity because our house was closed, so I was dealing with him all last week and making sure, I've been passing the word on to the other house because they're kind of waiting till that floor has been done this week before they pulled anyone in. So he should be getting a call from him today. I know I've been keeping on him too, but I just wanted to let you guys know that he's been very proactive about it. So.
Okay. Well, good. Thanks for sharing with that. All right. Let's go on to Sarah M. Royan. And Sarah, how are you doing?
I'm doing really good.
All right. Any concerns about the program or recovery?
Nope.
And let's see. I know you started working the AA workbook. And can you tell me where you're at with that?
I'm working on step 2.
All right. And can you tell me a little bit about that? What are you learning?
I just started it, so I'm not really sure yet, but I'm working on it.
Okay. Well, how about we go back to step 1? Since you've completed that, what did you get out of step 1?
That for my drugs, and I realized I used my mom a lot, and that kind of breaks my heart. Realizing that once I put it down on paper, it was more real, if that makes sense.
Okay. And what's your current relationship with your mother?
My mom is like my best friend. I talk to her every day.
Okay. So you probably discussed what you've, that step 1 and what you learned from that with your mom.
Yeah.
All right. How's she, what does she think of you being in the drug court program?
She thinks it's great because she says that I'm her daughter again. I'm not this using monster.
Okay. And let's let's see. I think she's also helping you with your license issues. Is that right?
Yep, I have an appointment today at Secretary of State.
Okay. And it's just a matter, am I correct, that you need to pay a certain amount of money and you'll get your license back?
I think so. I'll find out more today.
Ah, okay. All right. Well, I'm glad your mother's able to help you with that. And I think it's probably a sign that she trusts you and wants to support you there. And so that's all real good. What do you
Yep.
think your biggest obstacle is at this point as far as recovery goes?
I'm not sure. Just being able to get to all my meetings, which I managed to do so far, but my roommate's kind of getting sick and tired of driving me around.
Okay. So you think the meetings are important to maintaining your recovery is what you're saying?
Yeah.
Okay. Well, I know early on when you first got in the program, you had a relapse, and you've gone quite a ways now without any issues. And let's see. So do you think you've kind of left that behind?
I think so.
What do you think is different?
This time around, I know it's not worth it. And I keep telling myself in my head that my daughter would be heartbroken if I were to use again.
Okay.
And she's to the age where she's very vocal and she would let me know.
You say she is very vocal about it?
Yeah. Oh, yeah.
Okay. All right. Well, that's a good thing. All right. Well, is there anything else you want to share with us today, Mr. Moran?
Nope, not that I can think of.
Okay. Well, keep working on that workbook and keep up the good work anyhow. So,
Thank you.
all right. Let's go to Jacob Redmond. Mr. Redmond, how are you doing today?
I'm doing well, Your Honor. How are you?
Not too bad. So I hope you don't take this the wrong way, but this is, I think, the first time that you've been here, and I don't have to harp on you about any issues with PBTs or otherwise. So good job on that and doing well in the program.
Thank you.
What sort of concerns do you have at this point with the program?
Actually, I really don't have any concerns at the moment. You know, since the last time I saw you, I actually got a planner and have been writing in everything that I have to do and scheduling my week, you know, on Sunday for the week coming. And since I've done that, it's, I don't know, I guess writing everything down and actually crossing it off as I do it has been a huge help for me. So things have been going pretty smooth since I've been doing that. And, you know, I don't really have much of a concern. I think the only thing that I'm struggling with currently, which I don't even know if I'd really call it struggling. I think I'm just kind of being a chicken about it for whatever reason. But just, I have a guy that I want to ask be my sponsor. And historically, for me, it's always been hard for some reason to ask another guy to sponsor me. So that's really the only thing that I'm kind of dealing with right now, I guess. That is, I guess, it's not really much of a concern, but it's something that I I need to just kind of do. So.
Okay. Well, it is a requirement of the program that you get the sponsor squared away. So that should be some incentive anyway to break the ice.
Yeah.
And the worst that can happen is they can say they're too busy and they don't have time. But, you know, my experience is most people, if you're considering them for a sponsor, they're all too happy to help if they can. So, all right. Well, continue to work on that. And I do understand, you know, it's not easy to ask for help. And but in this case, you need help. And that sponsor is very important to your recovery. Now, you also wrote an apology letter to your parents. You want to, did you, I guess, what did you think about that when you were writing it?
Well, I guess writing it out, I kind of actually, I think I wrote like 3. And I guess I couldn't really, I got to a point where I feel like words, I would write it and then I would reread it. And then I'd just be like, this, you know, I've saw this before. And even the final one that I gave to Beth and actually ended up, you know, reading to my parents, it was, I still feel like I said most of that before in the past, you know, at certain times in my life. And I don't know, I guess I probably was just overthinking it, because I actually gave I read it to my parents at separate times just due to how it worked out. And, you know, I don't know if it's because I'm in drug court or, you know, I feel like they actually do see a change in me as well. So, you know, I feel like they actually heard what I was saying instead of just like, you know, letting it go one ear and out the other and just being like, okay, whatever. Like, you know, my dad and my mom, you know, they're not, I don't know, like we have a pretty big family and stuff, and, you know, they got their own things going on too, you know, like my mom being sick and stuff, but it's just nice to know, at least what I kind of gathered from them, is that, you know, they're not, obviously they're worried about me to a certain extent, but they're not as worried about me as they have been in the past. You know, I think me coming to them and telling them, and I think I was talking to Beth about this too, you know, me coming to them and telling them that I had drank, and, you know, just kind of being straight up about it. You know, I've never done that before. I in the past, it's always been like, I've done it and then I've hit it and then they've known and then I lied about it and then I kept doing it until it blew up in my face and everybody else's face. So I think that they, you know, I think that they were just happy that I was able to, you know, not keep going with it like I have in the past. So.
Okay, well, my guess is your parents were very glad to have you for the first time actually acknowledge, you know, the drinking and the way it hurts them and affects them. And yeah, they've at this point in their lives, in your life, they've got other fish to fry, but I'm sure it doesn't reduce how much they care about you and want to see you do well and be healthy. So
yeah, it was actually really cool.
Hang on just a second. Ms. Conlon, are you here? Okay, I'm going to put you in a breakout room with Ms. Worm. Okay,
thank you.
All right. All right, sorry to interrupt there, Mr. Redmond, go ahead.
No, I was just saying, it was really nice a couple nights ago, because my dad, he typically works pretty late sometimes, and my mom has to have her dialysis stuff set up and whatnot at night, and so I've been kind of, I'm obviously around and been able to help her with that. And the other night, she just out of nowhere was like, told me that she was very thankful that I'm here, and that she just said she was proud of me, and it was really cool because it's I mean I don't know. I guess like I've had my mom and dad say they were proud of me and like, whatever, but not in a long time. So it just felt good, it was just cool. It made me feel really good about what I am doing. Because, I know that I'm doing well right now and whatever, but, in my own head, I'm pretty hard on myself. So to have somebody, especially someone that I care about more than pretty much anybody, like my mom, say that to me, it was really cool. So.
All right, well, I'm kind of seeing a theme here today with families and Ms. Royan with her mother and Mr. Kozert and Mr. Ryder with their parents. And there's a reason why I'm helped start an organization called Families Against Narcotics, because your families obviously are as much or more affected by the drug use as you are. And, their families are always reaching out, trying to figure out what to do to help their loved ones. And so I'm just glad to hear that there are all these good connections going on, and that you, that's obviously a huge incentive for you to be in the program. And I want to take a moment just to applaud all of you for being in this program, because frankly, I've always thought it's probably easier to serve the time and get it over with than going through a long haul program like this one with all the testing and accountability and that. But you've chosen to try to make a difference in your lives, and not just more of the same. So I really applaud all of you for taking on the challenge anyway. And I know it's not easy, but anyhow. So let me see, who else have we got? Was there anything else you wanted to share, Mr. Redmond?
No, Your Honor, thank you.
We only have Miss Worm left for drug court.
Okay, that's what I thought. All right, we're gonna wait a minute here for Ms. Worm to come back. While we're doing that, since we've got some newer people on the line, Mr. Swisher in particular, I just wanted to introduce our drug court team members. Of course, you all know Beth, maybe better than you wanted ever to know Beth. But, and then we have Cherise Shively, who's the head of our community corrections office, and works closely with Beth and the program, and Charlie Hamlin from the prosecuting attorney's office, who reviews cases and refers the right ones to the drug court so that we get you in the program. And Mark Risk is the defense attorney on our drug court team. Always very knowledgeable about issues involving drugs and best practices. And so And usually we have Diana here too from Munson Behavioral Health. She's starting a new job though, and that may, she's still going to be involved with the program, but that may be why she wasn't able to be here today anyhow. So, all right, I see Ms. Worm is back now, so let's go ahead and take up that case. Ms. Worm, you want to unmute yourself at this time?
Yep.
All right, so Ms. Conlon, so you've had an opportunity to discuss the violations with Ms. Worm, and let's see, there's a recommendation for jail time. That's why I wanted her to talk to an attorney. So what does she want to do in this case?
Your Honor, I did discuss the alleged violations and the recommendations with Ms. Worm, and she does understand the alleged violations, and she understands her right to have a hearing and to have testimony presented with regard to the violations, but she is going to plead guilty to them today.
All right. So Ms. Worm, is that correct? You understand your right to an attorney, including one appointed at public expense, and you want to waive that and admit responsibility.
Correct.
And you understand you're waiving your right to any hearing as well.
Yes, I am.
Okay. And as with any probation violation, you understand the worst that could happen is you could be terminated from the program. You could be resentenced in circuit court on the original felony charge. That's obviously not what's being recommended, and I can tell you that's not what I'm going to do today, but you understand that that would be the worst thing that could happen.
Yes, I do.
Okay. All right. So is it true that as a part of your probation, in this case, you were ordered to go to regular NA meetings or 12-step meetings, and on July 3rd, 4th, and 5th, you did not go to those meetings?
Correct.
And even further, you gave false information to Ms. Lako about having attended meetings on those dates. Is that correct?
That is correct.
All right. And even though you are prohibited from having contact with your former boyfriend, Eric, you did do that, correct?
Correct.
All right. And then to those violations, how do you plead?
I plead guilty.
Okay. All right. So, Ms. Conlon, is there anything you'd like to say before I sentence Ms. Worm?
Yeah. Yes, Your Honor. I talked to Ms. Worm specifically about the violation of the no contact order, and sounds like it was a situation where she saw Mr. Edwards out in public, and instead of turning and walking the other way, she actually did talk to him. So we discussed that. She understands that in the future, if such an incident were to arise, she needs to just walk away and not have any contact with him. And she basically, Your Honor, is ready to start fresh again. And if you do impose the jail time, she can make arrangements, I think, with her employment to let them know that she's going to be in jail for a couple days. And I hope that, and hopefully that won't be a problem. She is starting counseling on Friday, so I don't know if it's necessary to impose that last condition of attending 2 group sessions until counseling begins, because she is starting this week.
Okay. All right. Ms. Worm, anything you want to say?
No, Judge.
All right. Well, I do want to say I'm a little disappointed that you don't want to apologize to Ms. Lako for lying to her. And really everybody here that is going to meetings, they're logging the time, and that's a bit disappointing. Go ahead.
I did apologize to Beth after I talked to her but if you would like me to do it again, I would right now. I am sorry for lying and not going to those 4 days on the meetings. That was totally my mistake, and that was my addiction talking, and I wasn't being honest or truthful until I did have my appointment with her. I did tell her the truth on it. There was no reason to lie about it in the first place, and there was no reason not to go to those meetings. So I am sorry.
Okay. Well, I know your excuse for not going to the meetings those dates was you had family in town, but you know, that's not an excuse, and your family should be supportive enough that they understand that this isn't just optional. It's kind of like going to a doctor's appointment for you. The lying, you know, there was a time when we would have been talking about removing someone from the program because of dishonesty, and we have done that in the past. And at least one team member was leaning that way. And this is the thing. If someone is being dishonest, it's very hard to work with them. And trying to just figure out if they're telling you the truth or not is, I don't know, you've lost some trust anyway. And that's a hard thing to regain. And but what I do recognize is this is addictive behavior. You know, people that are in active addiction, they're constantly having to make up excuses and explain things, and a lot of times you all know what I'm talking about. You got to lie to survive, and that's one of the things that we're trying to get you away from, because you can't, you know, we can't help you if you're not honest with us. And here's the other thing I want to talk to you about, this communication with Eric. I'm gonna I can't say for sure that there's been more than just the one contact where you happen to see him on a sidewalk, but I'll tell you right now, I don't believe that for 1 minute. I don't think that that's what's going on. And you were doing extremely well in this program up until I think you started having more contact with Mr. Edwards, and he has been a problem for you for a long time. And that's why there was this no contact in place. We thought we were giving you some help here as far as your son goes, and him being able to see him with your mother present. But apparently that wasn't some gift or something. That was something that was being done anyway. So I don't know what to say, except I think Mr. Edwards is, for whatever reason, he has a negative effect on your sobriety, and that no contact is going to, not sure why that happened, continue in effect. I don't want to affect your son any more than necessary, though I'm still going to allow for the third-party contact through your mom. But if there's additional contact with Mr. find out about it, there are going to be some real consequences. So I am going to follow the recommendation. You're going to restart your 90 and 90. There will be 3 days of jail to begin after your counseling session on Friday. What time is that?
It is at 11 a.m.
Okay. Are you working Friday?
I am. I just called my boss because I assumed that I had to go sit today and told her that I was gonna go turn myself in today and sit the 3 days. But if you
Oh.
want me to wait until my counseling appointment, I can do that.
Okay, well, I guess I'm gonna have you turn yourself in now then, since you've arranged that already with your work. So, I'll give you until noon today to get yourself turned in. Obviously, you're not gonna be able to do the groups if you're in jail this week. And your counseling, you'll be out in time for that at 11 on Friday. So I just want to say, Ms. Worm, I was very disappointed with the report in this case, and because I know you've been doing well. I think you really want to succeed here, and the contact with Mr. Edwards and making up facts about your 12-step program, I just see things going off the rails here real fast. So hopefully these 3 days in jail, you'll think about your commitment to the program, whether you want to get back on track, how you're going to do that. In fact, I want you to write an essay while you're in the jail explaining how you're going to get back in your recovery and be committed to it rather than screwing around and providing false records and hanging out with Mr. Edwards. So, okay.
Judge, is there any possible way that I can turn myself in after 3 o'clock when my mom gets home, because I have both of my kids here?
Okay, that is a reasonable request. So we'll go ahead and she gets back at 3.
Yes, she gets out of work at 3 o'clock.
Okay, so we'll give you till 4 p.m. then to turn yourself in.
Thank you.
All right. Okay, so well, anyhow, we're all set. Sorry to end on a down note here, but I've got a confidence that Ms. Worm's going to get back on track here and get back in the program here. So thank you all, and stay safe.
Judge Cooney,
Thank you.
Scott has told us of the group that we have coming up next. We have 4 that are in the jail: Miss Counselor, Miss Patson, Notzel, and Neil. And you may or may not know that, but I thought I'd let you know that.
Okay. Well, let's see. We've got Miss is that Miss Counselor there at the jail, officer?
You can respond.
Yes.
Okay. We'll need to wait for your attorney, Ms. Counselor.
Okay.
Let's see, that's Mr. Johnson. Who are the other cases you said?
Mr. Patson, Mr. Notzel, and Mr. Neal.
Cheers. Thank you.
Are the 4 that are incarcerated.
Okay.
Thank you.
When you get done, then you can just head back to your seat.
Thanks.
All right, so Mr. Warden is here now, and we'll get started then. This is People versus Summer Lynn Counselor, and that is file 215387FY. Mr. Warden is here on behalf of the defendant, Mr. Hamlin for the people, and Ms. Lako from our drug court team and probation office. So this is sentencing on the defendant's conviction of possession of methamphetamine. And Mr. Warden, have you had an opportunity to go over the pre-sentence investigation and the substance use assessment with your client? You're muted, Mr. Warden.
Sorry about that. I have not had the opportunity to do that. I did not get that from probation until yesterday, I believe. Anyway, I don't think that's necessary. Summer and I have discussed this matter at length. I believe the document to be factually accurate. The recommendation is for entry into drug court, which is absolutely what she wants. So I'm prepared to go forward with sentencing on that basis.
Okay, well, then, okay, what would you like to say on behalf of Ms. Counselor?
You know, again, Your Honor, these cases seem to be front loaded by the time we're here with the recommendation of going into drug court. I think it's totally appropriate. I certainly appreciate the offer that we received from the prosecution. I received probation's recommendations, and I appreciate those. Just so the court knows, the moving piece right now is she has no bond in the felony matter, and I'm trying to work with the Department of Corrections to get her a bond in that matter so she can be released into the treatment that's recommended. But again, given the fact that, you know, this is a drug court case, there is a positive recommendation for drug court. So I would ask the court simply adopt the recommendations.
All right, thank you. So, Ms. Counselor, is there anything you'd like to say before I sentence you?
I just appreciate the offer for drug court because I definitely have a problem with meth use, and I've just never really had the opportunity to be held accountable and strong sobriety under my belt. And so the last 40 days that I've been incarcerated have been just mind opening and have sobriety under my belt. So I just appreciate the opportunity. Thank you.
All right, thank you. Mr. Hamlin, anything for the people?
Just welcome to the program, ma'am. It's a difficult program. I tell everybody that from the get-go. And it would be difficult for anybody to do it, right? I mean, basically what we're going to do is ask you to change every facet of your life and do a lot of requirements and all that sort of thing. But I think the number one thing that I've seen over the years is for people being successful is just honesty. Everybody on the team, you know, obviously Ms. Lako will be the point of contact for you on a daily basis, but everybody on the team is here to help you succeed. And that's what we want. And I'm guessing that probably the last 40 days is probably the most sober time you've had consecutively for a while. So you're in the perfect place to start. Just be honest with yourself and us, and there's no reason you can't succeed in the program. So welcome.
Thank you.
And Mr. Hamlin, with regard to the pending probation violation, I assume the prosecutor is working with the with Mr. Warden to, I guess, advocate for getting Ms. Counselor into a treatment program as opposed to continuing in jail. And is that the case, or where are you at with that?
Yes, Your Honor, we would be happy to expedite that as much as we can. Because it's in circuit court, it would be just the probation department or MDOC would be handling that. So it technically falls outside our purview, but certainly when a hearing is scheduled and we're present, we will certainly advocate for that given her participation in the program.
All right, and that hearing isn't until the first part of August, am I correct?
It's August 6th, Your Honor. I'm trying to get that rescheduled to this Friday. I have not been successful yet, but I am still working on that.
And Your Honor, it usually presents a catch-22 because I know MDOC waits until the person technically has been sentenced into drug court. That way they can go from there. So usually they're good about after this step today. Usually they're pretty good about expediting the process.
Not that they don't trust, but unless you put her in drug court, that's when they look. Right.
Okay. All right. Well, that all makes sense then. So this is sentencing on the defendant's conviction of possession of methamphetamine, and the facts are that there was a home search done at Ms. Counselor's residence, and she was on probation at the time, for possession, I believe, to make meth or manufacture delivery through the 13th Circuit Court. And so during the search, they found a glass pipe, scales, razor blades, light switch plates with some sort of drug residue on them, and the defendant admitted she had used meth the day prior. Unfortunately, Ms. Counselor, I believe it's her 13-year-old daughter, was also in that home, and so Child Protective Services got involved, and the meth that was the basis of this charge was actually found on the defendant's person during a search at the jail after she was arrested. The substance use assessment indicates that Ms. Counselor doesn't deny she's got a serious drug issue. She went to treatment, I think it said 17 years ago at Dukoski in a 90-day inpatient program. And at some point, about 5 years ago, I believe it was, started taking meth to treat depression and some other symptoms, self-treat, I should say. There is a history, a family history of drug use, and unfortunately, that's there is a genetic component to this, and that's unfortunate that that's something that's part of your makeup, but it doesn't mean that you're doomed to it either. There are plenty of people with addiction issues in their families, and they're able to get past that. And actually, it looks like you had done pretty well for a long time without drugs. So anyway, this is a case where I believe there's a lot of trauma growing up, and unfortunately, Ms. Counselor has used drugs to try to deal with some of that trauma. On the bright side, Ms. Counselor was doing well on probation until this incident occurred. She's had successful probations in the past. Although she was on felony probation at this time this happened, there are 3 other misdemeanor offenses, kind of what you'd expect with drug behavior, the larceny and the malicious destruction of property and impaired driving in 2015. The defendant is, she has her GED and I think a year of college under her belt as well. And she's employed at a party store, which I'm not gonna, you said even to the evaluator that you didn't think that was the best thing for your recovery. And I don't think it is either. And so even though they would take you back, you need to find some other employment. And I'll tell you, you can do a lot better than $11 an hour. I just happen to know Target's hiring all shifts and positions for $17 an hour. So you can do a whole lot better. And so keep that in mind. Anyhow, I am, because of the diagnosis of severe amphetamine disorder, and the fact that Ms. Counselor seems motivated to change this behavior, I think this program would be helpful, and that there's a good chance that it could be successful. So I am going to place the defendant on a 12-month probationary term with the circuit court for the felony charge. That would be followed by a 24-month misdemeanor probation. And the prosecutor has agreed to a 1-year misdemeanor if the defendant completes the first year of the program successfully. So that's with a delay. And the drug court program. The costs of the program are $1,000, and that needs to be paid during the first year of your probation to be successful. Part of the program is going to be that you obtain and maintain full-time employment and get your life back together in all ways. You were homeless at the time that this happened. So another requirement is going to be that you find long-term stable housing by the time you're done with this program. And I know you feel like you've disappointed your daughter, and fortunately you still have a good relationship with her, but this is the program that's going to help you get that back together. And I've actually spoken to children your daughter's age who are very proud of their parents for being in this program, and they see the difference, and so I'm sure your daughter's going to be very glad to see you doing something very positive about the addiction issue. So the conditions of probation are going to be that you not consume or possess any alcohol, no illegal drugs, obviously, and no mind or mood altering substances. Part of this program is that you not consume marijuana, even if you have a prescription for that. Now, I can't prevent you from using marijuana if you have a medical marijuana prescription, but I would not continue you in this program by accepting entrance into this program. You're agreeing that you're not going to use marijuana. You're not to use non-prescribed medications, and you're not to reside where any of those substances are present or where there are any firearms or weapons, and you're not to enter any establishment that serves alcohol by the glass. I would make exceptions for work purposes, but not a party store. You know, if it were something other than a party store, I might consider it, but there are lots of job opportunities that don't involve being around alcohol, and I would encourage you to get something along those lines. You're not to operate a motor vehicle after consuming alcohol or illegal drugs, and you're not to operate a vehicle without a valid license, registration, and insurance. No over-the-counter medications without prior consent of the court, and you're not to consume any prescribed medications without prior consent of the court. You need to get a copy of the prescription to Ms. Lako first, so she knows what you're planning to put in your body. No violent, threatening, or intimidating behavior toward anyone. Be respectful of court employees and care providers. You're going to attend 90 12-step program meetings in the first 90 days of the program, followed by 4 meetings a week with written verification to the court. That sounds like a lot of meetings, but the idea is to get you very quickly involved in the recovery community and have people you can reach out to deal with issues that are bound to come up. You're to obtain a 12-step sponsor within 90 days after release from jail and any treatment program. Take and pass discretionary drug and alcohol testing, as well as random twice daily PBTs. You can use a SCRAM device for that, and twice a week drug testing. Again, all that after you're released from treatment or The jail time is 81 days in jail with credit for time served, although I would shorten that if you're released from jail on the probation warrant and a treatment program is available for you. And apparently you do qualify, or we're looking into whether residential treatment is something you qualify for funding. And if that happens, that's what will happen. Otherwise, it would be intensive outpatient treatment with a therapist and or group therapy as recommended. You're to reside in a recovery home if you don't qualify for residential treatment. And you need to agree to and sign an agreement that you'll follow all the conditions of the drug court handbook. Now that's a lot to digest, but Ms. Lako will go over all that with you in more detail once you're released, and she'll keep you posted as far as getting into a recovery program. So welcome to the program. I'm glad you're here. And as Mr. Hamlin indicated, everyone on the drug court team wants to see you in sustained long-term recovery. Not only is it the healthiest and best thing for you and your family, but it's also just happens to be the best thing for our community to have you back and healthy again. So this is not an attempt to find ways to trick you or pull the rug out from under your recovery. We're there to support you and do what we can to help you get through this, okay? All right. Yep, absolutely. So we're all set for today unless there's anything else for you, Mr. Warden?
No, Your Honor. Thank you.
Or Mr. Hamlin?
No, Your Honor. Thank you, sir.
Okay. And Ms. Lako, did you have a question? Go ahead.
Summer, could you please call NIMRI later today?
Yep.
Thank you.
Okay, good. All right, we're all set then, and welcome to the program, Ms. Counselor.
Thank you.
All right, we're going to take about a 10-minute break here while we get Mr. Patson here. Oh, actually 15 minutes because the hearing's not till 10:30.
Yep, we're a little bit of thing.
Good. Mr. Patson?
Yes.
Morning. Yeah.
Good morning.
Your hearing's not till 10:30, so we got about a 15-minute wait here. So just be patient, okay?
Okay.
Yeah.
There was a search warrant, Nathan Ritter had me review. Did you take care of that?
I
It
didn't.
was on Tammy's counter.
Oh, I do, yes.
You did?
So I
Okay.
have it, yes.
All right, I just didn't know about
There's
that.
another one on the printer that came in. I just sent it to the printer this morning, and I just, if I could go through here, grab it. And then that. the prosecutor and I see Mr. Johnson, but I now don't see the jail. But that might be just a problem on my end, at what I'm looking at, so. Okay. He's not, I'm calling right now. Thank you. Hi, could we get Mr. Patson back up on the video for in Judge Cooney's courtroom, please? Thank you. Bye. Looks like we have everyone now.
You were all set on my end. When you get
Judge
done.
will be right with you.
Thank you.
You're welcome.
Any issues, come and get me, okay? All right, thank you.
All right. So we're here on People versus Cyrus Patson, file 215023. Excuse me. The emergency motion is on file 204555 and 215023. And Mr. Johnson is here for the defendant, Mr. Atwood for the people. And so, Mr. Johnson, I adjourned this from last week so that the both sides, I guess, would be better prepared to argue bond. So, what's your position at this time?
Thank you, Your Honor. During the hearing, which continued for quite some time last week, I reached out to Amanda Webster about expediting a transcript from the sentencing hearing, because I think a lot of the testimony from Mr. Williams was at this sentencing. Judge Stepka ruled X and also indicated that he would strongly consider, if bonds were reduced in this case, to reduce other case that Judge Stepka has to a PR bond as well. Ms. Webster is out this week. She did try to get it done on Friday. but she was unable to do so. So I don't believe we'll have it until probably Monday or Tuesday of next week. My position remains the same. Obviously, Judge Stepka did take some testimony from the doctors, and he utilized that in crafting his disposition on the underlying felony matter, or that was reduced in his court. And he made the determination that testing and following his prescriptions and everything like that was appropriate, sending him back to the T house, making sure that, you know, as many safeguards were put in place as possible. And we did submit that judgment to the court. We remain confident, Your Honor, that this court should kind of read between the lines in Judge Stepka's decision, given that he did hear testimony from Mr. Patson's doctors, indicating that it is important for him to be on his medication, that it is important for him to be out in the T house working actively on his recovery. Because at the end of the day, you know, all of this litany of charges that Mr. Patson has picked up, all in some way or another stem around his addiction issues. And so his doctors apparently felt like addiction was not being properly treated while he's sporting that orange jumpsuit, and that he would fit in at the T house. I do believe that he's capable of community supervision. I think the T house is capable of doing that. I know he had a couple of, I think he was a little confused with testing at the T house versus the testing requirements of bond. But we would be asking for a modification to a PR bond at this time with the same conditions as Judge Stepka has ordered in his probationary ruling. And Your Honor, I think there's an extra safeguard in place, which is that Judge Stepka has ordered 180 days of jail to held in abeyance if Mr. Patson screws up. Judge Stepka also allowed HIDA in that case. So I think Judge Stepka saw something there. Unfortunately, I don't think Mr. Atwood nor myself have seen that, exactly what it was that he saw, because we don't have that transcript. But Your Honor, we would still be arguing for that PR bond here today.
Well, how are addiction issues related to tampering with a GPS device or violation of the GPS requirements that he not go near the victim?
So, Your Honor, I've spoken at length with Mr. Patson's grandmother about this issue. This appears to be a troubled relationship that Mr. Patson and this young woman have had for some years. He felt like he couldn't stay away from her, that she would show up every place that he would go to. What that should mean to him is just keep your butt at the tea house, because they're not going to let her in there. And he needs to just stay sort of under lock and key at this point in time. But he felt like he just could not possibly get away. He had a breakdown and did end up allegedly cutting his tether. So, Your Honor, he recognizes that that's not an appropriate reaction. However, we believe that that's something that Judge Stepka did consider in his ruling.
So do you know for sure Judge Stepka was even aware of the bond violations in my case, in my two domestic violence cases?
I can't be sure of anything without having been there or reviewing the transcript. So I would understand if this court wanted to adjourn this until we could get that transcript, because I agree with the court that that's important, that, both courts have full knowledge. And, it was kind of nice back in the day when we could walk between courtrooms and get things done that way, but we're in a different world right now. So I can't say that with any confidence. No, Your Honor.
So if I were to grant bond today, then it would be up to Judge Stepka to determine whether or not the defendant would be released.
Correct, because he still has a case in front of him. And all I have is Mr. Williams' indication and my client's indication that Judge Stepka said yours got reduced, that he would strongly consider reducing his. That being said, Your Honor, I do think that that's another safeguard that you have, which is, you can change his bonds to PR bonds. And at the end of the day, Judge Stepka, who made the initial ruling, is going to have to rule on that anyways.
All right, let's hear from Mr. Atwood.
Thank you, Your Honor. Well, I guess I'm a little concerned with playing one judge off the other. And it's kind of what's been going on, at least from my perspective. The sentencing hearing was a hearing in front of Judge Stepka where Mr. Williams presented the facts he wanted to present, and Judge Stepka made a ruling. Then the issue of bond was taken up later in the morning, and the people were there to present a different set of facts. And at that point, Judge Stepka declined to change the bond status of Mr. Patson at the time and left him where he was at. And then at a different hearing, obviously, Mr. Williams brought the issue up again. And there's a lot of back and forth of Judge Stepka said this, if you do this, and if you do this, Judge Stepka might do this. And I think we just need to look at the facts that are in front of us and not so much focus on what another judge may or may not have said or will not consider, because I feel like that's being used as leverage over the judge that isn't in the room to provide insight on what was actually said. So what I'd like to focus on is what happened with Mr. Patson after he got out of treatment. And his compliance, and I spoke again with Community Corrections this morning to get additional detail. His compliance in that first week after getting out of treatment was abysmal. He was provided the rules and the requirements of his house arrest and residing at the Tea House. He was required to not only present a proposed schedule for the week to Community Corrections, but then at the end of the week, provide verification for his whereabouts for the entire week. He did neither of those things. Community Corrections did not receive a proposed schedule for the week. They did not receive verification after the week had ended for where he had been. He did not return emails to Ms. Hildebrand. He did not return calls by Ms. Hildebrand. He did not respond to messages sent through his GPS device by Ms. Hildebrand. So they had no idea what his schedule was, what his plans were. He knew he had to remain at the Tea House. He then leaves the Tea House, obviously, to go back down to the splash pad there, where he had contact with the victim. That was not an authorized absence by Mr. Patson. That was a violation of the conditions of living there and a violation of his house arrest. And then we have been presented with several excuses for why he left. The first story was that he was going to see a sponsor. Then we've had another story about him trying to go get something to eat. And then I think the latest iteration was that he was with a person who then had to go down and get a slushie. So there have been several stories that have been told about why he violated, none of which would have justified, obviously, him leaving the house. And then after this was observed on his GPS unit by Ms. Hildebrand, there were again more attempts to get in touch with him through the GPS unit. Then after the fact, they finally received a voicemail from Mr. Patson indicating that he had a new number and that the other number that they had for him was no longer good. He had then come up with a statement about he had to go down to the omelet shop where he now had employment. Obviously, the omelet shop is nowhere near the splash pad. So again, that still is not an excuse for why he was down there in the vicinity of the victim. But again, even if that were a valid reason, his employment verification is something that, again, needs to be provided to Community Corrections. He had zero communication with Community Corrections. Ms. Hildebrand indicated that normally with house arrest defendants, there's daily contact about what's going on, where they're going, what they need to do. There just wasn't any of that. And so obviously that is a huge concern when we're talking about releasing him back into that same environment of which he wasn't able to comply with very minimal requirements from the get-go, the first week. So the testing issue, he had been through that before. He knew how it worked. He did miss a test. There was some belief, I think, on his part that the testing at the Tea House was sufficient. He knew that was not the case because he had been through it before. But in any, again, communication with Community Corrections would have at least assisted in figuring out what he was required to do and how to do it. So we have the issue of the bench warrant being issued. That was for several violations. That was for the no contact order violation. That was for the tea house violations. And Ms. Shively was able to go to the tea house around the time law enforcement arrived to take him into custody on the bench warrant. They were trying to talk through it with him, but she was there to see the defendant then cut his tether off, jump out the window, and run from law enforcement. And they found him hiding, I think, down by Boardman Lake after the fact. So that was all within the first week of him getting out of treatment and getting into the tea house. Really didn't comply with anything. So now we're asking that he be released into that same environment when he's given us no indication that he's able or willing to comply. The word that was used again, and I think I've referenced this before when I spoke with Ms. Shively, was that he is unsupervisable by community corrections. So I think when Mr. Patson has the amount of cases he has, when he has the history he has of not following through on things, to release him into that same environment really is setting him up for success. I think we could very well be back here with a 5th or 6th or whatever it is, criminal case charged against him. So I think the best place for him right now is where he's at. He needs to get a hold of the issues that keep bringing him back before the court. But to me, it's not safe. One, for the victim of a very serious offense. There was a no contact order violation. I think he had indicated she approached him, and I think that's true. From all accounts that we have, she approached him and said, "What are you doing here? You're on house arrest. You're not allowed to be here." So she's able to do that. She's not prevented from doing that by any order of the court, and I think that's a reasonable reaction for her to have at that point. But there was a no contact order violation. He had no reason to be at the splash pad. He's provided several reasons, none of which explain sufficiently why he was there. And so it's just, I don't think we're setting him up for success if we grant the relief that's being sought here today. I think he's where he needs to be for the time being and until he gets a hold of things a little better. Thank you, Your Honor.
All right, thank you, Mr. Atwood. Mr. Johnson, I do have a question. Dr. Clark had written several letters advocating that the defendant be given Suboxone while in jail. Is he currently receiving the Suboxone treatments or not?
I would allow Mr. Patson to answer that question.
No, Your Honor, I'm not.
Okay, all right. All right, well, what the defense is asking for is really, in my mind, an extraordinary request where the defendant has shown no ability really to comply with the conditions of bond. Mr. Atwood did a good job of laying out all of the violations. The fact that he is alleged to have tampered with his GPS, that he violated the court's order by not adhering to the no contact order, and while on community corrections, he was violated all of the rules really that they had set up, was uncooperative and unsupervisable in Ms. Shively's opinion. I am concerned about the medication issues that were raised at the previous hearing, but at the same time, that's something that I don't have control over. And I do feel that if Mr. Patson were released today, I would almost be surprised if he didn't return to the court with yet another charge against him. And actually, it would be the 7th open case, Mr. Atwood. And granted, 3 of those are driving offenses, but the others, some of them are fairly serious, and the prosecutor could have charged felonies in some of these also, but chose not to do so. So I just feel that Mr. Patson has no real ability to adhere to the conditions of bond. for whatever reason, and I don't have any belief that he will adhere to those conditions. And these are domestic violence charges. Protection of the victim is an important public safety concern, and so for that reason, I'm going to deny the emergency motion to modify bond in both cases. All right, is there anything else we need to do today, Mr. Johnson or Mr. Atwood?
Your Honor, I left the last hearing prior to, I think we switched over to a different defendant, but you did bring up the point of whether or not he's getting his Suboxone. I was just curious whether or not the court had made any ruling in that other case, and I apologize, I don't recall the name.
Well, the ruling that I stated on the record was that, and this is not in reference to the other case, the Austin Phillips case that I was dealing with, but in both cases, I made it clear that this court has no jurisdiction over the jail and its policies regarding provision of medication. I have placed on orders in the past, and I think I probably did this in Mr. Patson's case. I directed the jail to, I know I did, to follow Dr. Kelly's recommendations, Dr. Kelly Clark's recommendations to provide the Suboxone. But I view that as a recommendation or a consent by this court for that only. I don't believe that I have any jurisdiction over the jail and its policies regarding medication. For one, I am not a doctor. I'm not a healthcare provider in any way. And that service has been turned over to WellPath by the sheriff for better or for worse. And so that's the ruling there. Now, the jail has provided Suboxone in the past when I've indicated that I felt that it was necessary. But again, they're only taking that as my recommendation, and I'm not going to interfere with that other than to continue to write that on my orders when I think it's appropriate, and then it's up to the jail to decide what to do.
Very good. Thank you, Your Honor.
Dr. Clark had expressed concerns about the defendant's mental health deteriorating as a result of stopping his MAT. And, but, there's also issues here with him refusing to take his mental health medications. I understand 3 of them. So
that's not true, Your Honor.
Well, we had a hearing on that, and so I'm not going to get into that issue right now, but that's what I gathered out of the testimony and the facts that I know. So and if you're not going to take 3 out of 6 of your meds, then I do think it's the responsibility of the jail to figure out what they're going to do as far as mental health goes. They have to. So, all right. So we're done for today, and appreciate the arguments, and we're all set, Mr. Patson. And you can let the jail staff know that you're finished for today.
Okay, I have a question. Is there going to be another date that I will come in front of you?
All right. I'm going to let you, when's the next date?
Well, he has so many cases. Let me just take a look and see if I can find.
All right, Ms. Stocking's going to try to figure out when you're going to be in front of us again.
So it looks like you have a bond violation hearing on the 23rd. Well, it's scheduled with you on the 23rd, Judge Cooney, for the DV case on the 5023 case.
Well, I just ruled in that, so you can take
So on
that off
both
the
of
docket.
those, okay. So after that, I don't see any events scheduled. So nothing currently scheduled.
All right, it might make sense to schedule this for a pretrial conference then. I don't know if have we had
He's got a
final
preliminary
conferences?
exam. I'm sorry, Judge. He does have a preliminary exam on the felony case on August 3rd.
August 3rd is the next hearing date then. That's the preliminary examination in which file?
5414, and that is with Judge Stepka.
Okay.
My apologies.
All right. And I don't know if that's your case, Mr. Johnson, or Mr. Williams. Mr. Williams, yeah.
That's Mr. Williams's case. So I don't have anything scheduled for you next.
No.
I can explain in a breakout room, Your Honor.
Okay, so I'll put you in a breakout room with your attorney, Mr. Patson. You can discuss that some more with him, all right?
All right, thank you.
Thank you, Your Honor. Have a good morning.
All right, thank you, Mr. Atwood. All right, I think we're all set then until our preliminary examinations at 11.
Are you Mr. Switzer?
Yes.
Okay, I don't see your attorney yet, so we'll wait for your attorney and we'll get started.
Thank you.
You're welcome. I have no attorneys yet.
Oh, that's great. Okay.
Or at least I don't.
Oh, yeah, sometimes hiding in the background
Yes.
there. There's Mr. Hamlin.
I think I'm the only one here, Judge,
Okay.
other than with Mr. Switzer. But
Yep. There's Mr. Johnson. Okay, so this is file 215257FY, People versus Scott Tyler Switzer. Mr. Johnson is here on the defendant's behalf and Mr. Hamlin for the people. This is the date set for a preliminary examination. Mr. Johnson, have you discussed the hearing with your client? What does he wish to do?
I have, Your Honor, and I'm just looking for the offer. Essentially, Mr. Switzer would be looking at a drug court plea with a possession charge, and I apologize, perhaps Mr. Hamlin has this.
Yep. Your Honor, it would be a plea to count 1 and count 4 with entry into the drug court. We would need to do the waiver of the prelim first, and then the benefit for him of doing the drug court program. If he successfully completes the first year, both would be reduced to 1-year misdemeanors. It would be a use after that, and then an attempt lying to a police officer.
All right. Is that a correct statement of the plea agreement, Mr. Johnson?
That is, Your Honor.
Okay, so let's go to the waiver part of this first. All right, so Mr. Johnson, you're advising your client to waive the preliminary examination so that he can take advantage of the plea offer. Is that correct?
That is correct, Your Honor.
All right, no objection to the waiver, Mr. Hamlin?
That is correct, sir.
All right, and Mr. Switzer, you understand that your attorney's advising you to waive the hearing today, and that's based on the drug court offer that's been made. Have you been offered anything else to get you to waive your right to a hearing today?
No, Your Honor.
All right, and no one's threatened, forced, or coerced you in any way to get you to waive your hearing today, have they?
No, Your Honor.
All right, so Do you have the paperwork?
I do.
All right, so the examination has been waived. Defendant is bound over on the charges in the complaint. All right, and so I've signed the waiver. Let's go ahead with the circuit court arraignment, Mr. Johnson.
And Scott, bear with us on this. We got to do something before we get to the plea, just so it makes sense to you. But we would waive a formal reading of the circuit court felony complaint. We've been over the maximum penalties and trial rights with my client. At this time, we'd waive a formal reading and enter a not guilty plea as charged in that case.
All right, so I'll enter a not guilty plea for now. And now we'll go on to the plea itself. So let me pull up the complaint here first. Okay, so the plea offer, as I understand it, is that the defendant would plead guilty to count 1, which is attempted controlled substance possession of methamphetamine. Now it says attempt, but I'm not sure why, but it's still a 10-year felony. Is that correct, Mr. Hamlin?
It is, Your Honor. So I think we're all used to the attempt statute under the Penal Code. The Controlled Substances Act actually has its own attempt statute. The interesting thing about that is it adopts the same penalty as the underlying offense, which was new to me when I discovered it a couple of years ago. And so basically the genesis of the case is that Mr. Switzer ordered the 3 substances that comprise counts 1 through 3 off the dark web to be mailed to his address. He never physically took possession of the package with them in it. And so that's the reason for the attempt, sir. But yes, it is, and it was MDMA, but it is still the 10-year max.
Okay, so you'd be pleading guilty to that, the 10-year felony, as well as count 4, which is lying to a peace officer in a 4-year or more crime investigation. And that's a penalty of up to 2 years in prison. Counts 2 and 3, the other controlled substance counts would be dismissed. And the court would consider a drug court sentence. Is that your understanding of the plea agreement, Mr. Hamlin?
It is, Your Honor.
And Mr. Johnson, is that also your understanding?
Yes, Your Honor.
All right. Has anything else been offered to the defendant to get him to plead guilty? Or
No.
has he been threatened, forced, or coerced in any way to get him to plead guilty? Mr. Hamlin?
Sorry, sir. No.
Mr. Johnson?
No, Your Honor.
All right. At this time, I'm going to swear the defendant in. So if you could raise your right hand, Mr. Switzer, do you swear or affirm that the statements you're about to give regarding this plea hearing will be true to the best of your knowledge?
Yes, Your Honor, I swear.
Okay, you can put your hand down now. And so is that also your understanding of the plea agreement?
Yes, Your Honor.
And is there anything else that's been promised to you that has not been stated on the record today?
There is not, Your Honor.
Right? Have you been threatened, forced, or coerced in any way to get you to plead guilty?
No, Your Honor.
So is it your own free will to plead guilty?
Yes, Your Honor, it is.
All right. Now, I've already stated the maximum penalties, but I want to go over this again with you and explain the drug court program just a little bit. But do you understand that by pleading guilty, if you are not successful or you're in the drug court program, the worst that could happen is you could be, you would be convicted of attempted felony controlled substance possession of methamphetamine, and that carries a maximum penalty of up to 10 years in prison.
Your Honor, sorry, it was MDMA, Your Honor, which is ecstasy, but it's under the same statute as the possession of meth.
Oh, it is. Okay,
Yes,
of MDMA. Okay, and that carries up to 10 years in prison. Do you understand that?
I understand, Your Honor.
You would also have a conviction for lying to a peace officer in a 4-year or more crime investigation, and that carries a maximum penalty of up to 2 years in prison. Do you understand that?
I understand, Your Honor.
Is there any exposure to consecutive sentencing in this case, Mr. Hamlin or Mr. Johnson?
No, sir.
No, Your Honor.
Okay. Now, the way the drug court program works is if you are successful at the first year of probation, and assuming you're accepted into the program, those 2 felonies would be reduced to 1-year misdemeanors. On the flip side, if you're not successful, you could at worst have the probation revoked, and you'd be sent back to the circuit court for the purposes of sentencing only, and they would sentence you on those 2 felonies, again, to a maximum prison sentence of 10 years on the possession of MDMA and 2 years on the lying to a peace officer. You understand that, correct?
I do, Your Honor.
All right. I will also state that if for some reason the drug court team reviews your case and decides not to accept you into the program, I would allow you to withdraw your plea because it's based on the understanding you'd be accepted into that program. Do you understand that?
I understand, Your Honor.
All right. I need to go through your trial rights with you and make sure you understand all of those before I'm able to accept a plea. So please listen carefully. You have the right to be presumed innocent unless and until proven guilty beyond a reasonable doubt by the prosecuting attorney. And you have the right to a jury trial to make that determination. Do you understand all of those rights?
I do, Your Honor.
You also have the right to have witnesses against you appear at trial to cross-examine those witnesses and present your own evidence and witnesses, and the court would order those witnesses to appear if need be. Do you understand those rights?
I understand, Your Honor.
In addition, you have the right to testify at a trial, or if you choose, to remain silent, and that silence could not be used against you in any way. Do you understand that right?
I understand, Your Honor.
And finally, by pleading guilty, you give up the right to appeal that you would have if you went to trial. And any appeal of your conviction or sentence would be by leave, not by right, meaning it would be up to the Court of Appeals whether to hear any appeal of your conviction or sentence. Do you understand that right?
I also understand that. Thank you, Your Honor.
All right. And you understand that all those rights I just went over with you, you're giving them up by pleading guilty, correct?
I do, Your Honor.
And that's what you want to do.
Yes.
All right. So at this point, I need to ask you some questions to establish that there was, in fact, these 2 crimes committed. So is it true that on or about October 6th of 2020, you had ordered off the dark web, as Mr. Hamlin put it, some MDMA. Is that true?
Yes, Your Honor.
And you had arranged to have it delivered to you here in Traverse City.
That's true, Your Honor.
Okay. And specifically, you wanted it shipped to your address on Avenue B in Traverse City, and that's in Grand Traverse County, correct?
Yes, Your Honor.
And apparently that MDMA did not make it to your home. It was intercepted by Custom and Border Patrol at JFK Airport. And is that true?
That is what I've been told, Your Honor.
Okay. Now, there was a field test done for that, it says, and it did identify it as MDMA. You're not contesting that it was, in fact, MDMA that was being delivered, and that's what you expected to be delivered, correct?
Correct, Your Honor.
All right. Mr. Hamlin, are you satisfied there's a sufficient basis for count one?
Yes, sir.
Mr. Johnson, you too?
Yes, Your Honor.
All right. So then to the count one, attempted possession of MDMA, how do you plead?
Guilty, Your Honor.
All right. I'll accept that plea, find it's voluntary, accurate, and understanding. Now, did law enforcement at some point contact you about the intercepted MDMA and question you about that?
Yes, Your Honor. Sergeant T.
Did you make? Okay. And obviously, we know now, or you know now, that that's a 10-year felony to possess MDMA, correct?
Yes, Your Honor.
And did you lie to the investigators about your knowledge of that MDMA?
Yes, Your Honor. I reacted out of fear.
Okay. So what did you say to the officers that wasn't true and tried to throw them off course with their investigation?
Well, I admitted to my knowledge of the dark web and simply omitted the truth.
So you said you didn't admit, or you denied that you had ordered those substances, correct?
Yeah, correct, Your Honor.
All right. Let's see. And you knew that the people that were interviewing you were detectives with the Traverse Narcotics team. Is that correct?
Yes, Your Honor.
And your intent was, in fact, to knowingly mislead the officers about what had happened.
Yes, Your Honor.
All right. Mr. Hamlin, are you satisfied there's a sufficient basis for the plea?
Yes, sir.
Mr. Johnson?
Yes, Your Honor.
All right. Then to the count 4, lying to a peace officer, how do you plead?
Guilty, Your Honor.
All right. I'll accept that plea as well. Again, I find it's voluntary, accurate, and understanding. So the next step here is we're going to have the drug court team review your case next Monday when we normally meet and decide whether you're an appropriate candidate for the program. The fact that Mr. Hamlin has reviewed the case and is recommending it means that's likely to happen. But you never know. Sometimes there can be technical reasons why you aren't accepted into the program, as well as substantive ones as well. In addition, I need to get a pre-sentence investigation report completed. and you will need to contact our probation office to make that happen. And I want you to call them between 1 and 4 p.m. this afternoon. And here's the number. You got a pen handy?
I do not.
Go grab one and just take your time. Go get something.
I'm ready.
Okay, it's 231-922-6899.
Thank you.
Yeah. We'll also need to get a substance use assessment completed, and they'll talk to you about that as well, okay?
Okay, thank you.
So just make sure you call them between 1 and 4 p.m. this afternoon. Is there anything else we need to take up? Oh, sentencing date. When is that going to be, Ms. Stockey?
August 10th at 10 o'clock. Does that seem too far out?
No, August 10th at 10 a.m.
No problem.
That is quite a ways out.
That's the only date Tammy gave me, so I was working with
Really?
it. I could look in your calendar to see if there's a date sooner.
Our next drug court day would be what? There may not be enough time to get a report done.
So the next drug court date would be 2 weeks from today, right? So
Yeah.
that is the 3rd.
And then the 10th.
And the 10th is the following Tuesday after that.
Okay, well, I think the 10th is going to have to do, I guess I have to adjust my thinking that the summer is half over or more than half. Okay, so August 10th at 10 a.m. That'll be following our regular drug court hearings. And I guess, is there anything else we need to take up, Mr. Hamlin or Mr. Johnson?
No, Your Honor, I would just let Mr. Switzer know that if he wants to log onto YouTube earlier that morning at 9 o'clock, we do start the normal drug court, so he could get an idea of what he's in for.
Okay, that's a good idea. It's out there on YouTube, and, so it'd be a good idea for you to see some hearings first. Mr. Johnson, anything else for you?
No, Your Honor. Thank you.
All right, thank you both, and feel free to sign off at this time, Mr. Spitzer. So let's see, is the jail logged in here for Mr. Natzel?
You don't see them?
Okay, we'll have to.
Oh, please, thank you.
Get them dialed in. We've got 2 cases at least.
Yes.
Natzel and Neal.
And Your Honor, I know that Mr. Connolly, I think it was Antrim County. He sent me a note and just let me know that he was in court there, sir.
Ah, okay.
Let me take a quick look and see what her calendar looks like this morning. He should be done. Her last thing was at 10:30, and so he should be bopping in here any minute, I would guess.
Surprised they keep logging off. Usually they just.
Yeah, I don't know why they do that either.
There was only a 15-minute wait or so.
Yeah.
He is just starting the 1030 arraignment or whatever. I just went out on YouTube
Connolly.
to check, so we might do, well, we'll do Notzel first, and then hopefully by the time we get him done, Mr. Connolly will join us.
Okay.
Yes, this one and these two. What do I have here? Thank you very much. I appreciate it.
Hopefully they'll be here by the time I get back. I'll plug them in.
Okay, thank you.
Thanks, Scott.